Our minuscule brain cannot perceive what is the might and sophistication of nature. Yet, without me needing to understand everything, the world exists. The land is not real estate. You own real estate. That there is land and nature, and nobody owns that. This idea of time, my brain can stretch back 30 years. The land's millions. And I get to be connected to that.
Since the dawn of the Industrial Revolution, humans have viewed nature as a resource from which to extract commodities: fish, energy, minerals, timber. Nature is also seen as a place to dispose of waste, often without considering the impacts it may have on the human condition, whose lives depend on a healthy ecosystem. Today, these environmental challenges continue, but a new idea, pulled from ancient indigenous practice, may provide the earth with a rights-based solution.
You are the child, and that land out there, that earth mother of yours, is your parent. No human owns your mother.
Ecuador, a land known across the globe for its untouched ecosystems. Each year, hundreds of thousands of tourists travel to experience the country's rainforests and rivers, as well as the exotic Galapagos Islands. In Ecuador and across much of South America, the idea of Mother Earth, or Pachamama, as it is known in indigenous Andean cultures, has a presence in everyday life. There is no distinction between human and non-human nature.
Para los indígenas, la naturaleza es la madre tierra, la Pachamama. Y eso no representa una suerte de metáfora, es una realidad.
Hay mucho que aprender de las comunidades ancestrales. La confirmación de ciertos elementos de la naturaleza que ya se conocían milenios atrás. Antes que el reconocimiento a la naturaleza, creo que debe haber un reconocimiento profundo hacia las comunidades ancestrales. Y creo que ese es el punto de partida.
It is at this starting point that in 2008, the Constitutional Assembly of Ecuador considered taking a new approach to their political view of nature, as not just a resource, but as a living entity capable of being legally represented.
En el caso de Ecuador, la Constitución del Ecuador ya contenía el reconocimiento al derecho a un ambiente sano en su versión anterior. En el año 2008 se decide avanzar un poco más y se decide este reconocimiento de los derechos de la naturaleza, y allí se articulan tanto las miradas de diferentes pueblos indígenas como también las organizaciones ambientales.
For decades, Ecuador has struggled to protect its natural areas. Mining, oil drilling, even tourism are endangering some of the most biologically diverse places on the planet.
Este es un país que los 10 años pasados ha vivido por unos procesos de conflictividad ecoterritorial muy fuerte, ¿no? Porque al implantar los proyectos mineros o petroleros o agroindustriales, han habido como muchas tensiones por la gente que habita tradicionalmente esos territorios.
Ecuador's Yasuni Biosphere Reserve in the Amazon Basin sits on a multi-billion-dollar oil deposit. It also happens to be home to the Guarani indigenous people, numbering less than 3,000, with some clans living an isolated existence.
You know, the whole rights of nature, indigenous rights interface is particularly relevant in a place like Eastern Ecuador, where indigenous people are basically living fairly traditional lives in a way that's pretty similar to 1,000 years ago. Their absolute demand is that their resources be held intact. And if they're not, then they themselves disappear. So the human rights and the nature's rights really are one unit.
Más que nada teniendo en consideración que lo que hasta ahora ha ido sucediendo con el derecho ambiental no ha generado resultados sumamente positivos, sino que más bien la crisis ecológica sigue agravándose cada día. Entonces lo que me parece interesante de los derechos de la naturaleza es una gran oportunidad para empezar a pensar que no existe una única forma para tratar de abordar la crisis ecológica.
La naturaleza no es un objeto que se explota y se maltrata, sino que es un sujeto que se cuida y se respeta. Entonces es un cambio muy radical de pensar a la naturaleza como de objeto a sujeto.
The idea of nature itself having rights has existed among indigenous peoples for centuries. In 1949, American conservationist Aldo Leopold echoed the idea in his book, A Sand County Almanac. In it, he proposed a vision for a healthier human relationship with nature, writing that conservation is a state of harmony between men and land. He felt that eliminating the artificial boundary between people and nature would open doors to a new understanding. In 1972, American law professor Christopher D. Stone published Should Trees Have Standing?, which at the time presented the nearly inconceivable idea that rights be given to forests, oceans, and rivers. That same year, Supreme Court Justice and outdoorsman William O. Douglas made headlines when he issued a dissenting opinion based on Stone's article in the 1972 Sierra Club versus Morton case, stating that environmental objects should be able to sue for their own protection. Even though legal systems that govern the Western world are now slowly coming to consider the rights of nature concept, indigenous beliefs came to the table in 2008 during the Ecuador constitutional debate. Here was an opportunity to give nature the same rights held by individuals and corporations.
Política de la República del Ecuador.
Sin lugar a dudas, uno de los temas más interesantes, más anecdóticos también, del debate constituyente en Montecristi en el año 2007-2008 fue la introducción de los derechos de la naturaleza. La naturaleza ya no es más vista simplemente como un objeto a ser apropiado, a ser utilizado, a ser explotado, sino que comienza a ser visto como un sujeto que tiene derechos.
Gracias a todos quienes...
Ecuador had already recognized nature's role in good living, known as sumac cauce, or buen vivir, but going as far as giving it legal standing was still a stretch for some.
El debate se fue dando en diversas instancias, con diversas intensidades, pero soy franco, no creí que íbamos a caminar tanto en el tema de los derechos de la naturaleza.
Como muchos abogados consideraban que no podía darse, porque decían, pero ¿cómo la Constitución, la naturaleza puede ser un sujeto de derechos si la naturaleza no puede protegerse a sí misma, si la naturaleza no puede escribir un documento para presentarlo en la corte? Pero la comprensión vino cuando se comparó a la naturaleza con la aplicación de los derechos de los niños y cómo un niño recién nacido ya tiene todos los derechos de los niños, aunque no pueda ir a la corte y no pueda presentar un documento escrito. ¿Por qué? Porque es necesario la tutoría de alguien de esos derechos. Y en la naturaleza el acuerdo fue entonces que tutor de los derechos, representante de los derechos de la naturaleza, podía ser cualquier ciudadano del país.
Pero lo veíamos casi como imposible que realmente se incluya en el constituyente. Sin embargo, yo creo que el Ecuador estaba pasando por un momento muy preciso. Entonces queríamos cambiar un poco la historia de la Amazonía y de lo que estaba ocurriendo en el Ecuador.
En el campo del reconocimiento de la naturaleza como sujeto de derechos es revolucionario.
Y era un momento de transición política, de mucho cambio, que la gente esperaba cosas muy novedosas.
Recuerdo que algunos asambleístas de la derecha me preguntaban, en calidad de presidente de la asamblea, si lo que íbamos era a establecer una suerte de comisarías para el gato, comisarías para el perro, pues, comisarías para la lora, comisarías para el mono. Fue usado entonces como una cuestión irónica para burlarse de los derechos de la naturaleza. Pero se aprobaron los derechos de la naturaleza y estamos hablando ahora de la necesidad de contar con una declaración universal de los derechos de la naturaleza.
As a result of the Constitutional Assembly, Pachamama, or Mother Earth, was recognized as a legal entity and written into the Ecuadorian Constitution. Ecuador became the first country to establish the rights of nature at a national level. Nature legally could no longer be seen just as a set of natural resources to be exploited. In 2009, the nearby South American nation of Bolivia also referenced Pachamama in its constitution, acknowledging that nature had the right to protect and defend itself. These two reforms in Bolivia and Ecuador would soon have impacts elsewhere.
Efectivamente, yo creo que los derechos de la naturaleza ha sido uno de los, yo diría que uno de los grandes aportes que ha dado Ecuador y que ha dado Ecuador al mundo. Somos parte de la naturaleza. El ser humano no solo necesita de pan para vivir, no necesita pan y dinero. El ser humano necesita esta relación existencial con la naturaleza.
Aotearoa, the land of the long white cloud, is the Maori name for New Zealand. The country's two main islands, the north and south, are home to snow-capped volcanoes, ancient forests, and rivers flowing from rugged mountains to the ocean through canyons and across vast pasture lands. Nature is intertwined with New Zealand's national identity.
When we introduce ourselves, we refer to our mountain, we refer to our river, we refer to our marae, or that place, the home that our forebears, our ancestors were born. It's connecting us to place, it's firmly implanting our identity.
The first people to settle New Zealand were Polynesian explorers, the ancestors of the Maori. They established settlements on both the North and South Islands some 700 years ago. The Dutch mapmaker and explorer Abel Tasman was the first European to visit the islands, followed by Captain James Cook 127 years later. The British government signed a treaty with Maori chiefs on February 6, 1840. But the treaty had both an English language version and a Maori version that were not identical in content, as the Maori version welcomed settlers to share the land, but the English version stated that the Maori would become subjects of the British Crown. The treaty also introduced an alien and incomprehensible concept to the Maori, that of land ownership.
Take, for example, the Whanganui River. The people of the Whanganui River say the river is me and I am the river. And when I first looked at that, it seemed to me to be a little bit sort of something out of James Cameron's Avatar. But the more you look at it, the more you realize that the indigenous people have a completely different view of nature than European New Zealanders. And so it's a question of reconciling traditional ideas, indigenous ideas, with the way in which the Crown has been traditionally thinking over the years.
The Maori tribes, or iwi, view themselves as kaitiaki, or guardians and caretakers of the land, which is viewed as a living entity. They do not view themselves as simply owners, but as stewards.
When you are born to wherever it is that you were born on the planet, that there then becomes the thing that you are connected to. The land is not real estate. That there is land and nature, and nobody owns that. I don't care if you're the owner. I don't care if you're the CEO of something that I can't spell. I really don't care. You don't belong here.
It's hard to overstate the anger and frustration the Maori have felt for generations over the Treaty of Waitangi. On the North Island's Whanganui River, local iwi have sought rights for the river for over 140 years. Prior to European exploration and settlement, Maori grew crops along river terraces and built weirs to trap eel and lamprey during upstream migrations. They built over 80 settlements and fortifications along the river's 290 kilometers. The rapid-filled river was not simply a place that provided sustenance, it was a part of who New Zealanders were and are.
I was there before I came here. I might own the 1,400 acres that I've got. I've got a white man's piece of paper to say it's mine. but it's not mine. It belongs to everybody. I'm only the caretaker while I'm here. I can't take it with me when I go.
For centuries, Maori used the river for transport and trade, navigating it with large dugout canoes. The 1840s brought European exploration and missionary work to the Whanganui, and by the late 19th century, large river steamers carried passengers and freight from the coast to settlements upstream. The river was advertised as the Rhine of New Zealand, attracting thousands of tourists to the Whanganui. Today, the river and its lands are used for farming, forestry, and tourism. But decades of poor logging and agricultural practices have taken a toll on the Whanganui and its watershed, a well-known fact to both Maori and those of non-Maori descent.
If they hadn't cut a lot of that bush down, there wouldn't be so much debris coming down the river. And if they hadn't cut that bush down, the river wouldn't have flooded so much. Today, because of all the land development and the erosion problems, it's crazy. The environment is getting hammered.
Elsewhere in New Zealand, Maori have sought to recover their rights to Te Uera, a 2,127 square kilometer region of ancient moss-covered forest that is home to 7,000 tuhoi. This mountainous region, historically, was their homeland. The Tuhoi people are known as Ngātamariki o Tikohu, the children of the mist, a name that marks them as inseparable from the land. However, in the 19th century, the New Zealand Crown or government, aiming to control fertile Tuhoi territories, pushed them off the land in a deadly scorched earth campaign. Those Tuhoi that survived were relegated to a landlocked territory with no access to traditional fishing grounds, and they descended into extreme poverty.
I'm sure many outsiders think that New Zealand is very much an idyllic country, and in many respects it is. But the fact of the matter is, there have been wrongs happened. As the demand for land grew stronger and stronger, the Tuhoi people were increasingly locked out of any decision making. And then in 1954, without any discussion whatsoever with the people of the land, the particular area was made into a national park. And what that meant is that it was all governed by central government in Wellington. And those people who lived in the land, who had lived on the land for hundreds and hundreds of years, were totally locked out of its administration.
For 2 generations, that has been the arrangement. The National Parks Act took responsibility away from Tuhoi people and took it to the capital under the guise that they could better govern and manage a land they knew nothing about.
And it's my experience that if there were 2 parcels of land, one Maori land, one general land, and land was required for development, land would be taken under the Public Works Act, and it was invariably Maori land that was taken.
National park goals in New Zealand generally include preserving nature and facilitating visitation. But here, Te Uera National Park conflicted with a connection between people and place that was so essential to the Tuhoi. It was an artificial structure, a veneer of management laid over a land that did not need it.
Living with the land, living with nature is hard, but hardship is the thing that makes us tough. You then start to see how much you need each other. And so when government has taken that responsibility away from Tuhoi people, our relationships to each other eroded.
It was at this crossroads, both at Te Uera and on the Whanganui River, that the New Zealand government realized it needed to address the wrongs inflicted on the Maori. Could recognizing both nature's rights and those of the indigenous Maori people provide a solution to a century-old conflict?
In terms of the New Zealand recognition of the rights of nature, we were dealing with a number of these settlements and dealing with the aspirations of the various tribes. And then we had to say, well, if we transfer the river or ownership of the river to the local iwi, it'll be World War III. And if we transferred a national park, or what had been a national park, to the iwi, there would be trouble, because people would say we were giving away something that was their birthright. And so we had to try and explore ways in which we could reach just and durable settlements without getting ourselves into trouble. I mean, good old politics at its best.
And the result is a truly unique settlement.
And fortunately, the various groups that we were dealing with provided the answer. Get away from Western concepts of ownership into something else, and recognizing that maybe the river just owns itself. Maybe the forest, the uruweras, own themselves.
The Tiuera Act of 2014 granted the legal rights of a person to the former Tiuera National Park. For the 40,000 Tuhoi, the return of Tiuera was more than just about land having rights. It was central to Tuhoi identity, a key to a sustainable future. The agreement, part of a larger $170 million settlement from the Crown to settle the historic grievances held by the Tuhoi, also included a public apology.
The Crown apologises for its unjust and excessive behaviour and the burden carried by generations of Tuhoi who suffer greatly and who carry the pain of their ancestors. Let these words guide our way to a greenstone door, Tātou Pounamu, which looks back on the past and closes it, which looks forward to the future and opens it.
Under the Tiuera Agreement, the Tuhoi will share management of the lands with the Department of Conservation, but neither will own the land. The land will own itself. The goal is to seek to establish an intergenerational, principle-based system to manage Tiuera, drawn from Maori traditions and a focused responsibility to the land that involves asking what is best for the land rather than a set of regulations.
Well, how can a bunch of humans represent the voice of nature? It's a board that does not represent humans. We have this delightful conversation about things like, oh, well, that stakeholder wants that and that person. Yeah, we don't see humans. No, I am nature. Nature is connected to everything. I have a memory that is timeless. I can't see things in annual plans. For us, what applies here is the 1,000 years of history. We don't live in legislation.
3 years later, in 2017, similar rights were also extended to the Whanganui River. In a landmark decision that made global headlines, the Whanganui River was granted the same rights as a person. This recognition allowed the river to be heard in court. The Whanganui River claim settlement, known as the Te Awa Tupui in Maori, describes the Whanganui River as an indivisible and living whole, from the mountains to the sea, incorporating its tributaries and all its physical and metaphysical elements. Appointed with the care of the river are two guardians, one from the government and another from the Whanganui River iwi. The details will be worked out in time, and many in New Zealand and elsewhere in the world are optimistic about the model.
When one looks at it for the first time, it's strange. The idea of a natural resource owning itself. But once you reconcile it with the aspirations of the indigenous people, then there is a way through.
I'm the river and the river is me. You've got to respect the river. You know, she's a beautiful thing. It's our life.
Reconnection with land and nature makes us good people. It can work anywhere that people respect nature.
The rights of nature developments in New Zealand are part of a growing number of nations redefining their relationship with nature. Iceland specified in its 1971 Nature Conservation Act that humans and nature should engage in such a way that life or land be not needlessly wasted, nor sea, fresh water, or air polluted. The High Court of India's Uttarakhand state ruled that the Whanganui and Yamunotri glaciers, as well as lakes and forests in the Himalayan region, have legal rights. The court also ruled the Ganges River sacred to 1 billion Indians, and the Yamuna River have the same legal rights as people. The rivers, both badly polluted, were to be legal and living entities, which advocates hoped would improve efforts to clean up these watersheds. Though in July 2017, India's Supreme Court overturned the Ganges and Yamuna Rivers ruling, it did uphold the ruling on Himalayan glaciers, lakes, and forests.
Creo que en muchos países están habiendo algunas decisiones fantásticas, pero para nosotros que vivimos en zonas urbanas, creo que es muy importante la humildad de reconocernos parte de la naturaleza.
Para la gente de grandes ciudades, el distanciamiento con la naturaleza ha sido muy grande. Muchas veces los niños en las escuelas, en los colegios, no saben de dónde viene el agua que consumen. Entonces, el problema es cómo lograr que todo el mundo lo entienda.
Could the rights of nature take root in a populous, increasingly urbanized nation with the world's largest economy? In 2013, the City Council of Santa Monica, California, with broad public support, voted unanimously to pass a sustainability rights ordinance to help ensure that nature will continue to thrive.
Right now, it's really urgent in cities to really reconsider how we develop. And that doesn't just mean build buildings. How do we, as human beings, evolve and develop? We need healthy relationships with nature. And nature is a community, like the human community. What does that look like in law? That looks like in Santa Monica, the Sustainability Bill of Rights.
Santa Monica is a city of 100,000 people west of Los Angeles on the shores of the Pacific Ocean. It is just one of over 150 communities in the United States to enact a Community Bill of Rights. Santa Monica is a progressive, affluent community with a strong commitment to sustainability. But after hearing about rights of nature movements elsewhere, they wanted to take their efforts a step further.
Santa Monica has been looked at as a national leader in urban sustainability for decades. We were literally the first city with a sustainable city plan in the United States way back in 1994.
By 2010, when the Citizens United decision was advancing great concern about, are we going to have more money going to polluters? What are we going to do in a place like Santa Monica to safeguard what we're already doing? Is our plan enough? And hence, the rights of nature was laid on the table.
In 1994, Santa Monica established a comprehensive sustainability plan. The 2013 Rights of Nature Ordinance stated that natural communities and ecosystems possess fundamental and inalienable rights to exist and flourish. Residents can now bring forward legal action on behalf of nature.
And so really that bold statement on behalf of the city that we all have the right to clean water, we all have the right to clean air, and nature has to have the ability to thrive, and so nature has rights as well. We put all of those principles into the Sustainable Rights Ordinance, and we actually made it enforceable.
And so development here is a really big struggle. And some of the developers are big corporate entities. Their rights to gain profits do not supersede the community's rights, or most important, the rights of nature to thrive. What does that mean? There's a boost with some people's thinking about our planet and our watershed are not about profit making. And we need to not maximize its destruction for profits.
While the new law has been highly popular with residents of Santa Monica, implementation has not been as successful.
The city has struggled with the same thing that Rights of Nature has struggled with throughout the world, which is how do you actually make it enforceable? In the case of Santa Monica, we're also a very built-out city, which is very different from a lot of these areas that have a river system to protect, or a rainforest or a pine forest. And so the sort of nature that you would really sue over to protect, really it's a very urban environment in which we all live. And really Santa Monica Bay would be the one natural area that exists there. And the Clean Water Act is a pretty darn good tool to use, which is federal law, to make sure that Santa Monica Bay gets cleaned up.
Here in the States, the notion of environmental standing is fairly well established. So you don't need the habitat to have its own sort of legal existence for it to be protected if enough people care. Litigation's expensive, and I think certainly the city can do it on its own nickel, but for private individuals to do it, you have to get a lawyer interested, and the prospect of having to, pay a private counsel a $10,000, $20,000, $50,000 retainer is going to turn off a lot of people.
From the standpoint of actually any citizen using the law to enforce against violation of those rights, that has yet to occur.
Despite the rights of nature not having immediate legal impacts in Santa Monica, supporters believe that the idea can inspire people to rethink their relationship to nature.
Could it be made more effective? Absolutely. And I think every community needs to see what's the foothold that they can get and to internalize what are they already working on that could then be uplifted. And if nothing else, the rights of nature allows us to reconceptualize who we are, part of Mother Earth.
I think there's a real big question on the rights of nature, whether these are just of great value from the standpoint of awareness to the public. What's really interesting about the Santa Monica experience is back in the 1990s, our groundwater supply was so polluted that literally 0% of our water, our drinking water, was coming from our local groundwater. But this city boldly went after the polluters to actually clean up the aquifers and provide the public, restore our right to our local water supply to the public. It was extraordinary, and in a lot of ways it was sort of, the motivation to show that, this right for nature really can exist, and Santa Monica's already fought for it using different methods to make it happen. So that's why this work is so important, to give these sorts of examples of realizing that you can speak up for resources that can't speak up for themselves.
Several hundred miles east of California is the state of Utah, home to world-renowned national parks such as Zion and Arches. A desert state, Utah is facing environmental issues of its own. Great Salt Lake is under pressure from water diversions, an expanding population, and climate change. Stakeholders are exploring whether and how laws might be changed to guarantee a minimum inflow for Great Salt Lake, which currently has no right to water.
Whether you characterize it as a right of nature, or whether a river is entitled to have a water right, or a lake is entitled to have a water right allocated to it, that's a very difficult thing to do in a state like Utah, where the water is already fully appropriated. Convincing our very conservative legislature to do anything that would even be remotely viewed as treading on private property rights is really problematic.
Great Salt Lake is a Utah icon, as famous as the Mormon Tabernacle Choir or its powdery ski slopes.
I still remember the first day I came out here, and I stood there and looked around, and I was just blown away. I couldn't believe that a place like this existed.
The lake is an extraordinary ecosystem, vital for over 5 million migratory birds traveling north and south across the Americas.
And we get anywhere between 30, 50, even heading up towards 100% of North America's populations of some of these bird species.
Great Salt Lake also contributes to Utah's economy through the brine shrimp and minerals industry, as well as through the money spent by bird watchers, hunters, and tourists. All economic and recreational activities are dependent on adequate water levels in the lake. But changing climate and a population expected to double to 6 million by 2060 will create pressure to build more dams and divert more water from streams and rivers, including the Bear River, the lake's major tributary. In short, the future of this unique resource is threatened unless a right to water is established.
The water picture and the Great Salt Lake relationship is a very fragile one. The lake is very dependent upon water. So as the population grows and they consider what their values are, Great Salt Lake oftentimes is left out of that picture.
You've got greater water demand for irrigation, you've got greater water demand for cooling, for electricity. So we've got this squeeze from population growth and climate change. Utah water in general, and Great Salt Lake as well, is kind of trapped in the jaws of this vice that are closing on us.
The lake is at 4193 right now. The historic low is 4191. And so we're within 2 feet of the historic low, where the salinity of the South Arm rises to the point where the brine shrimp industry is impacted, where the harbors are impacted, recreation, birds. That's our biggest challenge, I think, going forward, is keeping water in the lake. Lakes don't do well without water.
The ways in which water has been used in Utah and the laws that govern it originated at a time when perhaps it made sense to incentivize people to use as much water as they could to help provide a strong economic foundation for the more arid states in the American West.
Back then, environmental concerns, preserving water for lakes, wildlife, and recreation, or supplying water to huge cities were not factors in determining water needs. As a result, current Utah water law is based on a belief system that no longer matches today's reality. Agriculture, which consists of about 2% of Utah's total economic output, uses about 80% of Utah's total water, while indoor water use is only about 2% of all water used in the state.
The system as it's currently set up actually works against using water wisely and incentivizes farmers to use as much water as possible, even though they don't actually need that much water. The use it or lose it principle. There's actually plenty of water to expand the population without developing new sources of water. We are not running out of water.
But even though plenty of water is available for Great Salt Lake, because it has no legal rights, the lake cannot purchase or lease water shares.
The law simply does not allow us to set water aside just to sit there in the lake for the values of the lake. The state water laws are such that the water in the lake is considered wasted. We're looking for an opportunity for groups to be able to go out and buy water rights, lease water rights from agriculture in order to keep water flowing to the lake. It's just we don't have a mechanism to do that right now.
One solution would be a viable in-stream flow law, which would allow water rights holders such as farmers to sell, donate, or transfer their water rights to a river or lake, providing a financial incentive. Utah water law does include protections to the environment, stating that a water right can only be granted if by removing the water from a river or stream, the environment will not be affected. While this part of the law has been overlooked in the past, pushing for its enforcement could return water shares to the state, thereby increasing water flows into Great Salt Lake.
The legal tool is there to force them to, but forcing it forces takings, lawsuits, and other things that will simply delay the implementation of any of this for decades while it works through the courts. If it can be done through market-based transfers without violating priorities and without violating property rights, I think we'll find willing sellers who would do a variety of things. The biggest problem with that is the environmental community has trouble competing on the economic basis, and that often leaves the environment on the outs looking in.
Could a rights of nature law help Great Salt Lake? Some think so, but gaining significant public support could take time.
I think the reason we have water concerns for Great Salt Lake is because the Great Salt Lake is an afterthought if it even makes it that far. And if we can build public concern about Great Salt Lake, then that'll build up into political support.
And to me, that's the key, is if this can be couched in terms of we are trying to sustain this resource for the benefit of all of us. And I think today it probably is more feasible than ever before.
Utah isn't unique. Many nations and communities across the globe struggle to provide rights for their ecosystems. Ecuador, despite being the birthplace of the modern Pachamama movement in 2008, has yet to see the law become fully operational.
I think people in Ecuador really like the fact that we have this rights of nature law. I think they're proud that this country was the first one to include that kind of thing in their constitution. But I do believe that there's a big chasm between this law as it's written and the way that it's put into practice. For Ecuador, I think in a big way, it is left quite empty.
In 2011, a section of the Vilcabamba River in Ecuador was damaged by road construction. An American couple who owned property along the river sued and eventually prevailed in court.
If you cut down the width of the river by half, the river current picks up everything that was thrown in and takes it downstream.
Ecuador upheld its rights of nature law, making global headlines and setting a legal precedent for the application of the rights of nature. However, enforcement of the ruling has proven difficult. Very little has actually been done to restore the damaged section of the Vilcabamba River. In other places in Ecuador, the law seems to have no force, as mining activities continue with no plans for the mitigation of environmental damage.
El Ecuador, a pesar de ser el país que reconoce el derecho de la naturaleza, permite que entre la minería a gran escala. En este mismo periodo, nosotros incluso hicimos un juicio contra la empresa Ecocorriente, que es la empresa que tiene el primer contrato en Cóndor Minador para el tema de minería a gran escala. Entonces, había muchos casos que eran evidentes, el tema de la minería era evidente para un país que nunca ha tenido minería a gran escala, que de repente lo tenga teniendo derechos de la naturaleza.
Por ejemplo, en la Constitución se sostiene la defensa de las fuentes de agua y de los cauces de agua. Sin embargo, de aquello, en este momento la ley de minería dice que a las mineras se les tiene que garantizar todos los servicios, incluyendo los servicios hídricos, lo cual significa que la minera sí puede afectar los cauces y las nacientes de agua. Estas contradicciones gubernamentales tienen, de hecho, una serie de condicionantes muy difíciles para que los derechos de la naturaleza se apliquen.
Primero, hay gente que nunca va a aceptar que la naturaleza tenga derechos. Ya en la práctica tenemos serias dificultades, porque para los abogados y abogadas, para los jueces y juezas, es difícil dar ese paso, ¿ya? Entonces muchos no entienden que ni siquiera se requiere un marco jurídico, leyes predeterminadas para poner en vigencia los derechos de la naturaleza, porque la Constitución abre la puerta para aplicarlos sin ley alguna. Es más, yo tengo mucho recelo de que se quiera establecer una ley que norme los derechos de la naturaleza, cuando los derechos de la naturaleza deberían permear todas las leyes.
Ecuador's world-famous Galapagos Islands lie 1,000 kilometers from the mainland. This unusual archipelago, where Charles Darwin did much of his pioneering work on natural selection, is home to a rich array of wildlife, including species found nowhere else on Earth. The islands, with their white sand beaches, animals, and tropical vegetation, are increasingly popular with tourists. In 2018, the island saw over 225,000 visitors, nearly 20 times the level from the 1960s. The population of the Galapagos has also increased from about 1,000 in the 1950s to over 30,000 people today. This human tide has created significant conservation challenges, with a greater need for freshwater supplies, electrical generation, and waste disposal. Increased construction, including that of illegal hotels and houses, pose even more challenges. Invasive plant and animal species are also threatening the Galapagos' unique biodiversity. 20 endemic species are now critically endangered.
La naturaleza que está sufriendo hoy en día por nuestra culpa, directa o indirecta.
In 1998, a special regime for the Galapagos Islands was established to help manage tourism, and a new law was designed to restrict migration to the islands. But these efforts only brought marginal improvements. A subsequent study recommended a cap on visitors, but the report was set aside, and its recommendations not implemented.
Basically, when we talk about rights of nature versus development versus human interest versus economy, all those things, it really boils down to money. It's like, what do we value? Is this worthwhile or is this worthwhile? We have now said economy is everything. And I think we're really moving farther and farther away from any kind of potential to recognize that nature itself has value and should be recognized as having rights to exist.
If tourism and development are detrimental to nature in the Galapagos, could the new rights of nature law be used to limit that development? Perhaps yes, but whether the law will be applied is another question. The money earned by tourism may limit the political will to enforce such a law.
Entonces va a ser un proceso dentro del Ecuador mismo cómo poder implementar aquellos derechos que va a tomar posiblemente décadas.
Es como cuando existía la esclavitud en Estados Unidos, haces todo el tema de abolir la esclavitud y que el esclavo lo pasas de objeto a sujeto de derechos, ya no es legal pegarle, ya no deberías pegarle, porque es un absurdo, entendiste que eso era un absurdo. Hoy por hoy estamos entendiendo que estas leyes que simplemente te maltratan a la naturaleza y la contaminan es un absurdo. Al tratarla como una persona deberías decir, ¿por qué no dejamos de contaminar? ¿No es cierto? Entonces es un cambio muy radical de pensar a la naturaleza como de objeto a sujeto, que tomará tiempo, definitivamente aquí en Ecuador todavía no lo hemos podido implementar al 100%, tomará un poco de tiempo, pero para nosotros es como una de las únicas soluciones de entender cómo lograr de nuevo este equilibrio con la naturaleza, de entenderla como una persona.
So what does the future hold for the rights of nature? Changes in the legal system are a reflection of social changes, which typically take time to take root and grow. The rights of nature movement reflects a new way of thinking about the human relationship with nature, and with patience and perseverance, change can happen.
Si queremos pensar en cuál es el significado del reconocimiento de los derechos de la naturaleza, a mí me gusta pensarlo como una oportunidad, es decir, una oportunidad para empezar a generarnos preguntas que por ahí se pensaban que ya estaban respondidas en cierto sentido, empezar a ver en el reconocimiento de los derechos de la naturaleza una puerta abierta para empezar a mostrar la diversidad de formas de trabajar con la cuestión ecológica que existen alrededor del mundo y que muchas veces han sido opacadas.
Creo que fundamentalmente es reconocer a la naturaleza como nuestra madre, a todos los seres vivos como nuestros hermanos y reconocer que la sociedad no va a tener una buena salida de futuro si es que rompemos esos lazos de familia con nuestra madre y con nuestros hermanos.
Los derechos de la naturaleza son una oportunidad, yo les vería como una oportunidad para construir otra civilización. Una civilización que vaya superando definitivamente las visiones antropocentristas, que no busque que el ser humano sea el centro y el dominador de toda la naturaleza, sino que todos tengamos la oportunidad, todos los seres vivos, incluyendo los seres humanos, por supuesto, de vivir con dignidad.
Despite challenges, the rights of nature movement continues to gain momentum. In New Zealand, following the Whanganui River and Tiuwera settlements, attention turned to Mount Taranaki. In 1865, the New Zealand government took the mountain from the local iwi and gave ownership of it and surrounding lands to European settlers. But the Māori view this snow-capped dormant volcano as an ancestor and seek to care for it in that fashion, not simply as one might care for a piece of property.
If you talk about legal personality, I mean, ultimately someone needs to be the voice. In order to make those decisions, you need a set of values. Now, that's tough, because whose values? You know, if you think about a mountain being your grandparent, it actually just starts with how would you like your grandparent to be treated? And so, you know, you think about that in the context of it becomes quite personal, and you can start thinking about actually what is important.
In 2017, a Memorandum of Understanding was signed by the Māori and the New Zealand government to give the mountain legal personhood. The Māori, hope their story can continue to inspire the world to reconsider our relationship with nature.
I think, we've got an opportunity to demonstrate what can be achieved, because we have a once-in-a-generation opportunity to develop a new model, which could be a blueprint not only for New Zealand, but I think globally, from the perspective of how we care for places, and I think also the relationship that we can have as people.
Today, over 100 nations have some form of legal rights for nature in their constitutions or federal laws. The United Nations has taken up the question of considering a universal declaration for the rights of nature. And though courts in industrialized countries seem less willing to grant nature a legal right as they have in Ecuador or New Zealand, each step provides a model and inspiration for others. They provide a foundation for a more sustainable future for humans and the physical world they share.
The reconnection of people with the land has to do with restoring our relationships to each other, regrowing our sense of purpose, our sense of community, and our kindness to each other. We get that because of what we observe about nature. We see the relationships between trees and insects, between mist and land, between rock and mud. And we see how in that extreme diversity, everything works together. Reconnection with land and nature is your sense of security about the future.